Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Exxon versus the Governor of Maryland. This case was heard in the Supreme Court of the United States in the year 1978. Let's go ahead and jump into the facts of the case. So the Maryland legislature passed a law which basically stated that if you are a producer of petrol, if you produce gasoline, then you cannot own a service station within the state. So this law meant that if you are Exxon, you're a producer of petrol, you can't own an Exxon service station. You can't own an Exxon gas station. If you're a producer, you can't own the gas station. That's essentially the crux of this law. Now, Exxon is challenging this law, and they're saying that it's a violation of the Dormant Commerce Clause. They're saying that it has the effect of discriminating against out-of-state companies, largely because there are no major in-state producers of petrol. So the effect of this law is to make it so no producers of petrol, no out-of-state companies can operate service stations in the state. And the governor of Maryland is defending the statute, saying that, this isn't discriminatory. It's just changing the market participants. It's not based upon interstate. It's just based upon if you're a producer of petrol. Now, the main argument that they give for that, and the justification that they have for the statute, is they're worried that if there was a fuel scarcity, if fuel became scarce, that these petrol producers would favor their service stations over the independently owned service stations. So, if you have a gas station owned by Randy and a gas station owned by Exxon, and there's a fuel shortage, well, then Exxon might say, hey, well, we're going to give our fuel only to our service stations, and sorry, Randy, that you can't get fuel right now, but that's just the way it is. So that was their main concern in passing the statute, and that was a justification for it. Ultimately, the court holds that this statute is not a violation of the Dormant Commerce Clause. The court holds this, stating that, this is just a prohibition on market participants. It's not really discriminatory, and it doesn't burden interstate commerce. It's just saying if you're a producer of petrol, you can't sell. If there was a producer of petrol in the state of Maryland, then they wouldn't be able to sell gas at a service station either. And so for that reason, it's not really about in-state or out-of-state. The law, is essentially facially neutral. It's not facially discriminatory, it's facially neutral. So, we're not going to say that this is even really a discriminatory law. And that's where the majority comes down. Now, the dissent, quite powerfully, I think, argues that this law is discriminatory because of the effects that it has on interstate commerce. This is, let's stop looking at the statute in the abstract, the dissent says, and let's look at its practical effects in the world. The practical effect of this statute is to make it so that no petrol producers can sell gas in the state. No petrol producers in general. The effect is that because there are no major petrol producers in the state. And so companies like Exxon, companies like Shell, are not able to sell their gasoline in the state. And so he's saying, yeah, you know what? Although on its face it might be neutral, there is a discriminatory effect on the that the statute causes. And for that reason, we should say, hey, this is a violation of the Dormant Commerce Clause. Further, he says, even if you think that it's discriminatory, someone might be able to argue that, hey, this is a narrowly tailored statute that is meant to serve a compelling state interest. And he says, it can't survive that level of scrutiny. There's not really a great reason for this statute. And the reason that Maryland gives of, protecting in-state fuel operators, fuel service station operators, is not a good enough reason to justify this discrimination. So that's the case. Let's just jump into a high-level breakdown of, what does a Dormant Commerce Clause analysis looks like. First, you're going to want to ask yourself, is the statute that the state has passed discriminatory? Is the state's action discriminatory against out-of-staters? That's the first question that you're always going to ask yourself. And then the second question that you're going to ask yourself is, if it is discriminatory, then does it serve a state interest, and is it narrowly tailored to do so? So if the statute's not discriminatory against out-of-staters, your analysis is just going to stop right there, right? It's not discriminatory. But if it is discriminatory, there's still a chance that it could be upheld and not be a violation of the Dormant Commerce Clause if the law is narrowly tailored to serve a compelling state interest. Okay, so to illustrate that, let's just jump into an example. Let's say that the state of Utah passes a law, the Utah legislature passes a law that says there will be no Japanese maples in the state. no Japanese maples will be in the state. It turns out that in this world that we're living in, jump into me in this hypothetical world, the only Japanese maples that are sold in the United States are all produced in Washington. So there's this massive farm for Japanese maples in Washington, and they're the only ones that are sold. So you could argue that, to the first point, that this law is discriminatory against out-of-staters, right? Because there's no Japanese maples that are grown in Utah. There's no Japanese maples that are grown in other states. It's just discriminatory against Washington. Now, it's not facially discriminatory. It doesn't say we won't accept any out-of-state Japanese maples from Washington. No, it's just saying, hey, we don't want Japanese maples in our state. So you could argue that even if it's not facially discriminatory, even if it's facially neutral, this law is discriminatory. And that's because it has a substantial effect on interstate commerce. It makes it so that Japanese maple producers can't sell their Japanese maples into the state of Utah. Now, second, you can have a pretty good argument here. Is there a compelling state interest, and is this law narrowly tailored to serve it? You could have a pretty good argument here about that. It would depend on the findings of the experts. Maybe there's some Utah scientists that have found that Japanese maples just carry tons of pests with them, and it basically ruins the agriculture in the state. And for that reason, there really is a compelling state interest that the state is trying to serve here. But absent those facts that these Japanese maples really do cause harm to the ecological system in the state of Utah, it would be hard for the state of Utah to argue that there is a compelling state interest here. And so, even if the court were to find that it is discriminatory, there's still a chance that it wouldn't be a violation of the Dormant Commerce Clause if there's a compelling state interest and if this law is serving it. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.